Thank you, Presiding Officer. I'm glad that extending the remit of the Delegated Powers and Law Reform Committee has created additional parliamentary capacity for dealing with bills that essentially come from the Scottish Law Commission. By their nature, of course, SLC bills address matters where they have established there is broad agreement on remedies for errors, omissions and updating existing legislation. Our taking of evidence and our discussions around the Succession Scotland Bill have been interesting and, for me at least, informative. But given that we all die, I'm sure that this is a piece of law that will ultimately touch us all in the disposal of our assets or our debts. Even those who have no assets and no debts cannot be assured they will escape the provision of this bill. Now, the complexity and lack of agreement on some issues in succession is, of course, why a future government will have to grasp the nettle of a much more wide-ranging restatement and reform. And Elaine Murray, if she is here to do so, can look forward, if she is again on the Justice Committee, I'm sure, to that pleasure. Now, personal circumstances illustrate some of this for me. My grandfather wrote his will, handwritten, and a mere 21 words. It said, "I, David Berry, do appoint my granddaughter Helen Mary Berry McGregor my executive and bequeath to her my whole means and estate." So votes can be that simple. The only trouble was when he wrote his will, my mother, his granddaughter, whom he named, was then 1, and when he died, she was then 3. So she wasn't legally capable. She was legally incapable. But the process, of course, meant that her father, who was administrator-in-law, became the executive dative to replace my mother, who had been the executive nominate. So he was appointed. And so you can do things in that particular way. Now, of course, I've also been touched in winding up estates in another way, in just over 10 years ago, when a small estate of a relative had to be wound up. No house was owned, it was simply some movable effects. She had written a little handwritten will that said her 2 daughters were equally to receive the proceeds, and simply that was done informally. There was no confirmation. Now, through the passage of this bill, I can tell you now, Presiding Officer, that I have apparently become and remain a vicious intromitter, meaning that because we didn't go through this formal process, I, for the rest of my natural life, will remain liable for any errors I committed in winding up that little estate and not getting confirmation. And yet, of course, the vast majority of estates, small estates, are dealt with on that basis. And I think that illustrates some of the things which may be engaged next time we look at this very complex area. Delighted we're getting rid of the Parricide Act of 1594 because we've invented the legal fiction in the courts that if someone is responsible for the death of someone from whom they're going to inherit, because the Parricide Act is quite narrow, it's father and son, that the legal fiction is that the person who would have inherited is deemed, notwithstanding they're still breathing and consuming food and so on and so forth, they are legally dead before the person whose death they were responsible for. Now, that works in proper terms, but it's a bit cack-handed, so it's a good idea to do something. Please. And the final thing, Presiding Officer, is we had a huge and interesting discussion about common calamities and sequencing of death, and the important thing is we worked out a way of which you can be certain that you're uncertain, and therefore the rules about uncertainty could be applied, but of course only when you're certain you're uncertain. Presiding Officer.